Welcome. I'm CJ Holmes, an independent real estate broker and founder of Homeowners for Justice. Today, I would like to present the findings that I have found, the violations and patterns of violations on foreclosure documents specifically by Recontrust Company NA, which is a bank and the wholly owned subsidiary of Bank of America. I analyzed 18 properties in 11 counties in California. You'll notice that there are a variety of counties. Some have more than one. Many have just one property that I've looked at. What we've found, and I've looked at these specific violations: false notarizations, forged signatures, assignments being recorded after the notice of default, a servicer being illegally named as a beneficiary, an impossible beneficiary named, questionable attorney-in-fact designations, questionable agency designations, missing false beneficiary or forged substitutions, assignments recorded after the mortgage trust cutoff date, any use of a defunct lender, MERS receiving or assigning value without the authority to do so, any violation of the OCC's Office of the Comptroller of the Currency's cease and desist order in April 2011, any contempt of court where these banks have violated the consent judgments from the United States District Court in April 2012. And each of these violations, the combined total of which would lead to void notices of default, void notices of sale, void sales, void trustees' deeds on sale, and void grant deeds. We all understand that if the foreclosure document paperwork is void, is forged, fake, fraudulent, any sale of that property is illegal. So, what I'd like to start with is going through each of these violations quickly, showing you what I have found. Then you can review the documents yourselves to verify. So violation A, 72% of these 18 properties had false notarizations. This is where the notary signature is either forged, like I have an example here of Shannon Stieg, notary. You'll see the different signatures, and these are on documents that I personally have collected. Or a notarization of a forged signature. If a notary notarizes a forged signature, it is a false notarization. So, for example, T. Civillano, here's the original signature sample we have now on file, and here is a forged signature. And you'll notice that this notary, R.J. Greer, has to be a false notarization. Even if that is his signature, and he signed that, he is notarizing falsely and claiming that the person standing in front of him, that he has seen the documentation that that person is who he says he is, and it's obviously not. The next violation, B. 89% of these 18 properties had forged signatures on them. For example, Irma Garay is a classic one used on notices of default. I have a few copies of her signature here. I want to again remind you that every forgery, multiple different signatures that I have found, I have found them on the documents myself. I've helped dozens of people, gotten dozens of documents, and turns out many have the same signature, same names on them with different signatures. I've put the link here to my website, the hofj.org, and this is the suspicious signature page, suspicious documents and signatures. You'll note that I've started by showing and showcasing John O'Brien's discovery. He discovered the same thing in his registry. This is not a surprise. And then down at the end, you'll see a list of names on documents, and these are names that I personally have been collecting and logging, putting on the website for other people to use as examples of the forgery on their documents. Violation C. 17% of the 18 properties had an assignment recorded after the notice of default. Here's just a sample of the worksheet that I typically use. So in this case, the notice of default was filed in May. There was a substitution filed after that, then a notice of sale. Finally, there was an assignment. It's the assignment that gives the owner, the beneficiary, the right to foreclose. When an assignment is filed after the notice of default, it's void, because the assignments and the beneficiary have to file the notice of default. They're the only ones that have the right to sale. And I'm quoting here from the California Civil Code 2932.5, the power of sale may be exercised by an assignee. 44% of the properties had a servicer illegally named as an assignee or a beneficiary. Here's an example. I've snipped this straight out of a document. This is an assignment of a deed of trust. And you'll note here that it says, for value received, the undersigned holder of a deed of trust, this happens to be MERS signing it, but we're not going to get into that right now. This is who they've assigned this interest to. Bank of America, N.A., successor by merger to Back Home Loans Servicing, L.P., formerly known as Countrywide Home Loan Servicing, L.P. These are servicers. This is a servicer. According to the federal law, 15 U.S.C. 1641, a servicer of a consumer obligation arising from a consumer credit transaction, which this section discusses as mortgage loans, shall not be treated as an assignee unless they were or are the owner of the note. And in this case, the first original lender was First National Bank of Arizona. Bank of America was not and is not the owner of the loan, and yet they are receiving assignments and the beneficial interest. This is fake and fraudulent, and it's illegal. Violation E, 56% name an impossible beneficiary. Here's another example. This is the Bank of New York Mellon. Notice that the undersigned that's giving away the beneficial rights, MERS, Mortgage Electronic Registration Systems, Inc., is giving to all the beneficial interest, notice, under the certain deed of trust and the obligation with the notes, including all the interest. They're giving this interest to the Bank of New York Mellon, formerly known as the Bank of New York, as trustee for the benefit of the certificate holders of the Seawalt, Inc., Alternative Loan Trust 2005-59, Mortgage Pass-Through Certificate Series 2005-59. And I'm going to have a couple more slides specifically on this because you need to understand it, and I need to show you this documentation. The original lender, the originator, if you will, is Mortgage It, Inc. You notice that the date of this loan and deed of trust was in 2005. You'll note that this assignment was done in September 2011. Now, let's look at how the actual legal transfer of assignment of the notes into a mortgage security should have been done. This is the correct order of assignments. It would come from the originator, we saw that was Mortgage It, to the seller, and I've snipped here a link specifically from the pooling and servicing agreement for this particular trust, the Alternative Loan Trust 2005-59 Mortgage Pass-Through Certificate Series 2005-59. You'll see that's right down here on this snip. So the originator should have assigned the interest, the beneficial interest in the note, to the seller. You'll note that the seller, the major one here, is Countrywide Home Loans, Inc. There's a couple of other sellers there. To the depositor, so there would have been an assignment to the depositor, which is, right here we can see, Seawalt, Inc. To the trustee, which would have been the Bank of New York. You'll notice here on this pooling and servicing agreement snip that the master servicer is Countrywide Home Loan Servicing, LP. Now, you take this specific assignment that we just looked at, and this particular owner contacted the Bank of New York Mellon because she was told by B of A that they owned her note and were the ones foreclosing on her, and she needed to talk to them about it. So she emails him. This is directly out of her email. This is a direct quote out of the email back she got from the people at New York Mellon, from the VP. The VP is writing in this email to Home Loans Bank of America, saying she, the owner, said that many people from Bank of America have informed her that she will have to contact Bank of New York Mellon because it is showing us as the owner. He's stating, which is true, we just saw it on her recorded document, they stated Bank of New York Mellon as the owner. He is objecting, saying, wait a minute, we are only the trustee for this loan, and we cannot, pay attention, we cannot authorize any remodifications, foreclosures, or short sales. She also gave me the number to a lawyer that represents Bank of America that sent her a letter stating that Bank of New York Mellon is the owner. His name is Philip Italiano. There are attorneys all over the place that the servicers are using to illegally file these illegal, fraudulent, forged documents to take the homes of people illegally. We need to stop that. 28% of these 18 properties used questionable attorney-in-fact designations. I've snipped one here for you. Notice that it says Deutsche, here we go again, another trustee of a mortgage-backed security. Deutsche Bank National Trust Company as trustee under the pooling and servicing agreement relating to the Impact Secured Assets Corp. Mortgage Pass-Through Certificates, Series 2007-2, by its attorney-in-fact, Bank of America N.A., successor by merger to Home Loan Servicing, where we read that before. And of course, signed by a robo-signer, known robo-signer. I've got several different signatures for Lauren Stone on file, notarized by several different notaries. My understanding is that an attorney-in-fact designation requires a power of attorney to be recorded either with that document or on record at the county. I cannot locate any power of attorneys. That would be left up to the Attorney General and the prosecutors to delve into to determine if these are actually fake signatures, fake attorneys in fact, or if there is some substance to the claim. In this particular case, however, they've made that claim, and even if that's a legal claim, they've used a robo-signer, a forged signature, to do the document. Now, I want you to understand the pattern that I see on Recontrust's notice of defaults. What I've got here is a little bit confusing, so just follow along, and I will use the cursor to show you where I'm looking at. In August 2011, there was an assignment of the deed of trust, and it was assigned to U.S. Bank National Association as successor trustee, to Bank of America, blah, blah, blah. So the assignee and the beneficiary is U.S. Bank National Association. That's who they've named as the assignee, the beneficiary. A couple of months later, they're filing a notice of default, and every notice of default used by Recontrust uses this formula. This is their boilerplate form. Notice that they want you to contact this assignee, the beneficiary, U.S. Bank. See, it's a straight copy from up here. But it's always care of Bank of America N.A. And you'll notice I've snipped over here another little exact same spot on the notice of default where, contact Bank of America N.A., care of Bank of America N.A. This is because they literally use an assembly line to plug in the names of the last assignment, and it's always care of Bank of America N.A. That's why it doesn't really make a whole lot of sense sometimes when the assignment was Bank of America N.A. Now I want you to also notice that in this notice of default, look down here, they're all identical. Notice is hereby given that Recontrust Company N.A. is acting as an agent for the beneficiary. And you go, really? I thought we had a beneficiary. Oh, but we're only supposed to contact the beneficiary on the notice of default. And now every one of them is signed as Recontrust, acting as agent for the beneficiary. And notice who they say the beneficiary is on the on the notice of defaults, to secure certain obligations in favor of Mortgage Electronic Registration Systems, Inc. as beneficiary. So regardless of anything filed prior or after these notice of defaults, every notice of default says this. This is their pattern. This is the way they just fill out the paperwork they've learned over the last 5 years. They can pretty much send whatever they want to the recorder's office in any county in the nation, and it will be recorded. And then in most lawsuits, the recorded documents are presumed to be accurate, and they can get away with it. We beg you to stop them. Violation H. 67% of the trustee substitutions are missing, forged, or use a false beneficiary. Here's an example of a substitution of trustee. This is a false beneficiary. It's giving it to the servicer. This is a forged signer signature. This is Lauren Stone. And this is notarized, so it's got false notarization, notarizing forged signatures. Legally, according to our laws and statutes, this trustee substitution cannot be used to have a valid notice of default. And yet, these homes are being foreclosed. They are being sold at auction. They're being taken back by the servicers. They're being sold to other folks. And the owners are just being booted out of the home, evicted. Violation I. 89% of the assignments that are filed on these 18 properties were obviously recorded after the mortgage trust, the mortgage-backed security trust cutoff date. And I want to read you a little paragraph, which is pretty standard verbiage on the pooling and servicing agreements. It's always found in section 2.01, the conveyance of trust fund. And in this case, this is based on the case we just talked about with the trust fund, the trustees of the mortgage-backed securities being named as beneficiaries. And in that case, the depositor, Seawald, shall report to the related custodian and the certificate insurer the status of updating all applicable assignments with MERS within 60 days of the closing date. Now, if you recall, that was the loan was done, I think, in July 2005. So it had to have been done legally in 2005. And yet you remember that that assignment was filed in 2011. I want to specify here specifically these verbiage in these pooling and servicing agreements states the seller, now remember the seller back there was Countrywide Home Loans, Inc., further agrees that it will not and will not permit a servicer, now who was a servicer? Countrywide Home Loans Servicing LP. The banks are masters of the corporate shell game. So the seller agrees it will not and will not permit a servicer to, and each related servicer agrees that it will not, alter the information referenced in this paragraph with respect to any mortgage loan during the term of this agreement, unless and until such mortgage loan is repurchased or substituted in accordance with the terms of this agreement. So every assignment done after the trust closing date violates the pooling and servicing agreement. We already know that they violate the mortgage trustees as the beneficiaries. I could not discover any use of a defunct lender. However, it has come to my attention that I have not had time to do the research, and it might be that with extra research we discovered that either of these entities were not active, that they were technically defunct. They were closed down and not operating since Countrywide Home Loans, Inc., since May 2008, or Back Home Loan Servicing LP since July 2011. And the reason I bring this to your attention is because of some information we've discovered about other entities like Washington Mutual using defunct lender names after they have been, the corporations have been shut down. Violation K, 94% of these 18 properties use MERS to receive value and assign notes without authority to do so. So I've taken the same assignment we just looked at, and I've highlighted the areas you need to really read and understand. First off, this is MERS, has been signing this assignment. MERS claims in this assignment for value received. So MERS is claiming to receive value. MERS. Claiming to receive value, and it is claiming to give value and to assign not just the deed of trust, which a lot of the lawsuits are saying, well, the owners signed a deed of trust that said MERS, had the authority to do things with the deed of trust. Well, maybe, maybe not. However, they are assigning the note and obligations described, and the monies due, and to become due and payable. So there's a lot of bankruptcy courts that have actually ruled now and said, excuse me, MERS has no authority, has no standing, is not a beneficiary. It was never their money, they never loaned anything, they never risked anything, and they can't give value and they can't accept value. Just bringing that to your attention. 94% of them, of course, violated the Office of the Comptroller of the Currency, the OCC's cease and desist order in April 2011. They were told to cease and desist deceptive practices such as forging signatures, false notarizations, giving false beneficiaries. These are deceptive practices, and they were told to stop it. And they did not. Anything filed after April 2011 that has these kinds of problems with that paperwork has violated the cease and desist order. 72% are in contempt of court. They have violated the consent judgments that they signed in April 2012, and they are continuing to use deceptive practices. Again, the same list of deception. And these lists of false substitutions, assignments, beneficiaries, notarizations, and signatures lead to void notices of default. These are notices of default that have no legal standing according to our laws and statutes. So to summarize, I want to point out that this is the percentage of the violations on these 18 properties that were all filed. The foreclosures have been filed by Recontrust Company N.A. 72% had false notarizations. 89% had forged signatures. 17% had assignments recorded after the notice of default. 44% illegally named the servicer as a beneficiary. 56% started naming the beneficiary to the trustee of the mortgage-backed security. 28% have the questionable attorney-in-fact designations. 100% had questionable agency designations, because every last notice of default uses Recontrust as an agent for the beneficiary, which they name as MERS, which may or may not be the beneficiary according to the paperwork if you were just to look at the paperwork on that property. 67% have missing false beneficiary or forged substitutions. 89% of have assignments that were recorded after the mortgage trust cutoff date. Those that did not have assignments recorded afterwards didn't have an assignment. So 100% of the assignments that were filed, of course, violated the mortgage trust cutoff date. I could not find a use of defunct lenders, but more research may uncover that. 94% have MERS receiving and assigning value without authority. 94% violate the OCC cease and desist order. 72% were in contempt of court. And it turns out all of those violations void the notice of default, which voids the notice of sale, which voids trustees' deeds on that property, which voids the grant deeds that are being given to new owners on that property. So it turns out that when you add up all of these violations, 100% of the notices of default on these 18 properties are void. They are illegal. They violate numerous statutes. And we already know that they have Recontrust has filed so many of them, they have to understand and know what they are doing. They know they are causing intentionally to have these fraudulent and forged documents recorded in our properties all over the country. That's a violation of the penal code. And you'll note that the defaults are void based on all of these problems with the paperwork. Therefore, 100% of the notices of sale that were filed are void. And 100% of the trustees' deeds on sale are void. And 100% of those deeds granting the ownership of the property to a new owner are void. Now, this is what the owners demand. We, as property owners, under the laws and statutes of the state, and this is every owner in every state. I'm in California. I'm demanding that my attorney general and the prosecutors in California do three things. We are demanding that they get an injunction against the foreclosure mills. Stop Recontrust. Stop all of the foreclosures being filed on all securitized loans. The fact is, every foreclosure mill is forging paperwork, and we demand they stop it. Stop the fraud now. We also demand you start a criminal investigation. We want criminal investigations against all firms engaged in forging foreclosure documents. And we want a quiet title lawsuit like what Nancy Becker is doing in Pennsylvania. And in that lawsuit, we want you to demand that all securitized, it's for all securitized loans in the state, whether they're in MERS or using a MERS lookalike database shell corporation, and demand that the documentation be made accurate on each property with these securitized loans, and that these entities pay the recording fees. In the foreclosure mill injunction, in stopping the filing of any more forged paperwork on any other properties in the country, we want you to understand that we have now other proof coming to light. I've got these links up here. Wells Fargo, a whistleblower in one of their foreclosure document mills, has claims and has proof that Wells Fargo has engaged in systematic, large-scale alteration of mortgage notes and fabrication of related documents in preparation for foreclosure. Here's the link to that article, and that all of these links will be in the comments section under this video. Now J.P. Morgan Chase Bank is foreclosing on hoodwinked homeowners in where they have been naming a non-existent, this is a defunct lender violation, non-existent Washington Mutual Bank FA as the beneficiary. And here's the link to that article. The facts are these. The more the prosecutors and attorney generals really understand how they have manufactured these foreclosure documents, the more they will understand that it's not about did the owner stop making the note payment. It's about did the note get paid? Has it already been paid? Because it has by many different ways. And if so, then why are these banks being allowed to forge foreclosure documents and take the homes? It's for their own financial benefit. That is the answer. Under the criminal investigation, we want criminal investigations against every foreclosure mill on a securitized loan. We are confident that every last one of them is forging documents. We know that Doc X has already pleaded guilty. We know there's a settlement coming down March 15, 2013. We know that LPS has a price list where for $35 they'll create an allonge for you. We want LPS brought down. We want these foreclosure mill attorney firms criminally prosecuted. We now have foreclosure defense attorneys claiming that Bank of America never acquired any loans from Countrywide. and that Chase never acquired any loans from Washington Mutual, and that One West never acquired any IndyMac loans. They had loss share agreements with the FDIC where the people, the FDIC, takes the hit, and they, banks, receive the foreclosure proceeds. These criminal foreclosure defense attorneys are now claiming that every statement on every securitized loan document, which would be the assignments, all the assignments for value received, is a lie. Owners demand a quiet title lawsuit. This would be against all of the securitized loans in the state, demanding accurate documentation for each one of them and payment of all recording fees. For example, in the Pennsylvania quiet title lawsuit, she's doing the lawsuit against MERS and MERS Corp. It was filed by County Recorder Nancy Becker on behalf of all the recorders in the state. They seek declaratory and injunctive relief, and they are attempting in court to force MERS and its members to record every single missing document to every single MERS mortgage and pay the appropriate fees that would do for each recording. We demand the same for California. Here is the link to that article. The judge would not allow, he threw out the civil conspiracy complaint, but he left intact her other claims to file accurate paperwork and to pay the recording fees. We want the prosecutors in the Attorney General's office to do criminal conspiracy against these fraudsters. It has been a criminal enterprise, and they have knowingly and intentionally illegally foreclosed on every securitized loan that they can forge paperwork for to make money for themselves. It has ruined people's lives. It has ruined the economy. It is continuing to allow fraud as a business model to rage unchecked. We demand it be stopped. I just want to briefly point out that to date in California, we have lost almost 1 million homes to foreclosure, and that's not counting short sales, all those or deeds in lieu of foreclosure. This is counting just those that were actually taken to auction, and either the banks took them back or sold them to a third party at the steps, at the courthouse steps. So if you added all of the short sales that have been going on, this number would be far higher. And right now, the number of homeowners, this would be homes, condos, and 1 to 4 units, not the rest of the commercial property that's just fallen off a cliff because the economy has been ruined. We have almost 60,000 owners right now facing auction. That would be in the next 2.5 months. Please stop the devastation now. Give us an injunction. Stop the foreclosure mills from filing any more forged and fraudulent documents. We now know that every foreclosure that Recontrust Company did was void. Thank you so much.